Alex here with part 33 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are: number one, my case is completely and totally over. It's closed, it cannot be reopened, and that's because my ex's parental rights have been terminated. Part 2, the underlying purpose of the series in a nutshell is to provide my viewers with one big example of my high conflict child custody ordeal from beginning to end in chronological order. We left off in part 32 with the end of the case, at least officially. I filed a petition in part 1 asking for joint physical and joint legal custody, and by part 32 the court entered an order granting joint physical and joint legal custody as I had requested, against my ex's objection. The process was somewhat convoluted, at least in the perspective of a non-attorney. It was convoluted. Looking back, it probably would have been a very low-stress, run-of-the-mill case if I had an attorney, because I wasn't asking for anything that was not very difficult to get, at least with, for an attorney. And joint physical and joint legal custody at the time was pretty much becoming the norm. And because I didn't have an attorney, it ended up making it a whole lot more complicated. It made me think that it was unreasonably delayed, when in reality, waiting around 8 months to get that order when the other person opposes vehemently is probably pretty average. And of course, not understanding the legal process sort of, in my eyes, caused me to have to go through more stress than an ordinary person would have. But it wasn't like I had a choice between representing myself and hiring an attorney. At the time, I was dirt poor. I wasn't able to get any support, at least not financial support. And for those reasons, it wasn't a choice at all. I just had to, well, I guess you could say it was a choice between not even trying and representing myself. So I chose to represent myself over not even trying. And it was a whole lot more complicated, convoluted, stressful, and in my opinion, it did probably give my ex more of a desire to really push for things that she shouldn't be pushing for because I didn't have an attorney. It's that whole idea of, well, yeah, this isn't normal, but maybe he'll be screwed over because he doesn't have a lawyer. That is a common, tactic that people do when they think of, winning in court. They do take into consideration the fact that their opponent doesn't have an attorney. It does kind of open the door to getting things that are not appropriate just because your opponent doesn't know what's going on. So anyway, as I mentioned, the case was officially closed because that was a final judgment entered in Part 32. However, as many of my viewers know, it does not end in 2009. My case continues on well into 2016. So if my case is officially closed, then what's going to be happening from now until 2016? The answer to that question is post-judgment proceedings. In child custody cases, particularly high-conflict child custody cases, the post-judgment proceedings dwarf the actual, the normal case. The case closes, and then motion after motion gets filed asking to modify things: child custody, support, visitation. The parents can't agree. There's typically one, sometimes two parents who thrive in the conflict, and so they continue to file post-judgment motions for years and years on end, sometimes all the way up until the child turns 18. Now, that doesn't happen in my case because my ex's parental rights are terminated. However, if I hadn't terminated her parental rights, I'm sure it would have gone on well until my son was 18. So, one of the things that I wanted to go into was my mindset. I was elated. I was joyous. I was happy. The stress was beginning to wane. I was able to get some sleep. I was calming down. I felt like the world made sense. The legal system worked. And that was quickly going to begin to sour, because one of the first things that I asked my ex was about splitting the IRS tax refunds. And I think her objection was that she didn't trust me. So since she didn't trust me, I said, fine, you don't have to trust me. Let's at least alternate. Let's trade years. I'll claim him this year, you claim him that year. And then I got a response about how under the federal statutes, she was required to claim him every year, whether I liked it or not, because she had him for 60% of the time and I had him for 40% of the time. So that didn't sound right to me. I did some research online. I found out that's alternating years for parents who share custody. Even parents who don't have joint custody do this. For example, one parent has primary physical custody, the other one just has visitations. Even those parents do this. Anyway, I found out that it was reasonable, and my next step was to go back to court. It was going to be a situation where she was not going to alternate tax years unless she was forced to do so. So I filed a motion. Now this motion, I've taken a look at it before going over it with my viewers, and it looks to me like something that I copy pasted online. I don't recommend doing this. This is really dangerous because you have no idea if what it is you are copying from actually cites applicable law, or maybe it at one time did cite applicable law but something changed. It's much better to do your own research, or at least use the document as sort of a guide. You could maybe check those cases out and see if they do seem to apply. Don't just blindly paste them without looking into them. That's what I'm trying to say. Now, I thought about going through these cases and determining whether or not they actually were applicable or not, but I'm not going to waste time on that in this video, because even if I go through all that work and I do find out that the cases that I cited are applicable and controlled today, one of these days that may change anyway. And so the point that I try to make with my channel is to not tell people exactly what to use in their papers, but to sort of get people thinking on their own and doing research on their own. So me going into all of this and finding out if those laws actually control and are applicable isn't going to help anyone maybe 2 or 3 years from now, because the laws could change, the case law could change anyway. And for all I know, I could have an opinion that what I cited was correct and I could be wrong. So I want to remind people that I'm not an attorney. I don't have a license to practice law, and the purpose of the channel is to get people understanding how the procedure works and how to look into these things on their own, not tell them exactly what it is that they need to put into their documents to get a precise outcome. So with that being said, let's go ahead and take a look at what I have filed. So here we have my motion, and it's a little bit wordy, so I'm just going to paraphrase it. My motion to have my ex and myself ordered to file Form 8332 with the IRS. Form 8332 is the form that the IRS requires be filed if you're going to alternate claiming your children with your ex. Now, in my particular situation, Form 8332 was around, but I have heard that it always, or it wasn't always around. In fact, I guess it came out sometime in the 1990s. Somebody can feel free to post down in the comments below if they know the history of this, but I guess prior to Form 8332 being a thing, you would have to send them a court order, and I suppose that they figured out in high conflict cases, this is a disaster because you'll probably get conflicting court orders from both sides, with the high conflict parent trying to deceive the third party entity, whether it's a teacher or a medical provider or a police officer, or in this case an IRS agent. Doesn't seem to matter, that it's a common thing that they do, and sometimes they'll just play dumb and say they didn't know the orders were changed. But anyway, this way the IRS sort of steps out of the role of being a lawyer or a judge and trying to review court orders, and steps into the role of just being told what to do. And so what happens is they are told what to do by the parents. The parents file Form 8332 instructing the IRS as to who is going to claim what child during which year, and the form is filed by the parents under order of the court. So if any shenanigans are being played with that particular part of the process, the IRS no longer concerns themselves with it. The judge will now concern themselves with it. So for example, if the judge orders a parent to file Form 8332 and they don't file it, that judge can hold them in contempt of court. They can order them imprisoned and have them sit in a jail cell until they sign the document. If the parent sort of tries to fill out the form incorrectly, I would say that's the same thing. You could take them back to court. The point is, the IRS no longer wants to be involved in the squabbling between two parents on this issue. If those parents have a problem with who is claiming the child when on that submission, Form 8332, those parents can take that back to court and have the contemnor punished under the law for playing games with Form 8332. So what this motion does is brings the court into the process and asks the court to order myself and my ex to file that form with the IRS consistent with who's going to claim the child which year. Let's move on into the form. One of the things I didn't mention was, I'm not sure about this. I haven't done any research, but my understanding is that now that IRS Form 8332 exists, you can't use the old method, which was to provide them with a court order. My understanding is that Form 8332 is mandatory going forward from a specific date, which I can't remember. I still feel like it's in the 90s. Again, go ahead and take a look into this if anyone wants to. Post it down in the comments below, and I'll pin your comment to the top for anyone else who's curious about the history of the form. But I just wanted to go ahead and mention that I don't think that you can choose one or the other. My understanding is that this form is what the IRS demands at this point. Now, that's not to say that you still couldn't try to hold the parent in contempt of court. If the court entered an order that you're supposed to alternate tax years and somebody violated the order, that should still be enforceable. But the IRS isn't going to get involved in this anymore. That's what I'm trying to say at this point. And the easier way to deal with this is to just have the IRS given the form, because then you won't have to stress out about it if your ex tries to pull a stunt and claim the child on a year they're not supposed to, because the IRS has a specific form from them telling them that they agreed not to do that. I'm going to go ahead and scroll down. And we've got the points and authorities here. I'm going to take a look at the first paragraph really quickly, actually. Let's see. I am identifying myself. I'm still not identifying myself as improper person. That's eventually going to happen. I should be doing that in the first paragraph, the introductory paragraph, but I haven't done that yet. So that's one thing that I'm going to point out, but don't worry about that so much. It's just kind of one of those things that the court expects, but even if it's not there, they can find that out on their own. Moving down, we have the factual background, which is going to detail the facts that are relevant to what I am requesting. It's not going to contain every single fact in the case, just the ones that are relevant. The first one is that we share joint physical and joint legal custody. The second one is, I don't know why I mentioned this one. It's not really, it's kind of assumed that we provide food, clothing, and shelter. So for some reason I put that in there. And the next line is that we share the child 40 and 60% of the time, respectively. This is good that I put this in there because I probably anticipated my ex was going to try and say, hey, I have the child for longer. So I just kind of got ahead of that one and just went ahead and let the court know about the ratio in my motion so it wouldn't become an issue on opposition. It might still become an issue on opposition. I actually know what comes of this motion, but this time I won't let you guys know. You'll go ahead and find out in part 34. I'm thinking about doing that less often to make it more of a sort of a mystery as to what's going to happen, rather than just tell you guys in advance what happens. It might be a little bit more interesting to not know until I actually get to that part in the series. So I'm going to try to do that more. Let's see here. We've got next page, which has the argument. So I'm citing here the IRS Section 152, which allows income tax dependency exemptions for a parent who has custody of the child for a greater portion of the calendar year. And what I am saying is that federal law does not preempt the family law court. It's a really weird way of describing it. It's not very formal, but the judge will understand what I'm saying. And I guess what I'm reading on here, it looks like I'm arguing that the judge has the discretion to order exemptions despite the IRS having a statute that says that the parent who has the child for more time is supposed to claim the child. And this is true. The IRS has a form that actually allows that. A Form 8332 allows a parent who ordinarily would have the right to claim a child to give that right to the other parent. So the IRS does have a statute that is sort of a default position, but they also have a form and other authority that allows for them to bend that rule, or I guess you could say it's just two different rules that conflict, and allows the other rule to take hold or take precedent under certain circumstances. And in this circumstance, it is that the release of claim on Form 8332 was filed. Here I have a case that I've cited, Monterey County v. Cornejo. I do not know if this case controls or if it's applicable. As I mentioned earlier in the video, I'm not going to spend time checking it out and researching it. This is what I am convinced I just pulled from somebody else's form online. Again, doing that is not a good idea. It is risky. You have no idea if it's applicable law, but that is something that I did at the time when I didn't understand how perilous representing myself was. Now I get further and further along in representing myself, and I start to realize that this is not something a person should ever do, but at the time I didn't know, so I'm sure that this was a copy-paste. And I'm assuming that this case was somehow cited as a case that allows a family court to order over the objection of the custodial parent, or in my case, the parent who has the child for more time, to order over their objection that parent to give up half the time or half of the number of years that they would be able to claim that child. Moving on, I can see here that the rotations are fair and forthright. I'm asking the court to order us to both execute the form, and I'm asking for oh, look, it says Form 832 also allows a custodial parent to revoke their release. And should either parent revoke the release so long as the parties share joint physical custody, such an action should be a contempt of court. I was already getting ahead of my ex on this one. I probably assumed that she would comply with the order and submit the form, and then later on revoke the form and say, hey, you can't hold me in contempt because I actually complied with the judge's order. I did submit the form, like I was told to submit it. He didn't say anything about revoking my Form 8332. So I probably, I'm starting to at this point realize that she can't be trusted and that she does try to find gray areas in the court order to exploit. So I talk about this sort of way of approaching your case in the video, Anticipating the Response. It's a great video for anyone to watch if they haven't seen it yet, because it teaches you the importance of trying to figure out what your ex might do in response to what you're trying to get them to do. And by thinking in that way, you can sort of cut off some of their paths of escape, which is what I ended up having to do throughout the entirety of my case. So scrolling down, we've got the affidavit. And this is just something that provides a sworn statement from me under oath that the facts stated in my motion are true. And it's just one of those things that's required under the court rules, and it's one of the ways that a court can hold your feet to the fire if you lie in an effort to obtain a hearing. We got a notary stamp here. The affirmation, which is just included in my custom paper. I'm no longer using that self-help paper and just stapling it to the back. I just insert the sentence at the bottom, which is just what the clerk of the court, or deputy clerk, you could say, looks for when they are trying to determine whether or not a social security number is in the document. They don't actually check the document for social security numbers. Maybe they'll skim through it, but they won't check it in high detail. What they do is they look for this affirmation, and as I mentioned, they might skim it. And if they have this affirmation here signed by you, they just take your word for it that there's no social security number in there. Scrolling down, we have the motion opposition notice. I've talked about this several times. This time, a final decision has been entered, so the first box is checked. And since it has been entered, we have to look on and check the other boxes. In this case, I am not trying to change a final order, so I just check no. And because I have checked no there, I don't have to pay the $25 filing fee. I can file this document for free. Oh, why did I attach this? I didn't need to do this. I already had an affirmation included. So I'm still figuring this all out. I'm still learning. I'm still representing myself, relatively new. It's probably been about a year-ish that I've been representing myself. I did not need to add this affirmation because I already included an affirmation, but erring on the side of caution, I went ahead and did it. And this is the self-help version of the affirmation. It's the one page. You know what? I think I know why I did. I think it's because the motion opposition notice, when you download it from the internet, it has this included. That's probably why, and I assumed that since this was included with the other document, I had to include it. But we have to sort of get our thinking out of that. It's sort of, we're like following instructions throughout most of our life. And when we get these forms, we think we're supposed to fill out the forms because that's what the instructions say. And of course, the instructions would be consistent with the law, but it's not really what they do when they prepare the forms. They can't really get it all to fit perfectly into whatever legal situation that you are happening to go through. And in this case, I prepared a custom document and I included the affirmation on my own. So I really didn't need the affirmation that was stuck in the form to be included as well. But I'm not really at the point where I'm understanding how all this legal stuff works. And I'm still kind of giving a lot of deference to the forms and the packets and assuming that whatever is in there is probably right. Anyway, doing this isn't really going to harm my case. It's a superfluous paper. But over time, if you're going to represent yourself, you want to look less and less like a person representing themselves. You want to get more and more in line with what an attorney is doing, because that's the more efficient way in which the court reviews these documents. Non-attorneys don't know what's required, so we file superfluous stuff all the time, and it just gives them more work in figuring out what it is that they're supposed to actually look at, what's actually applicable, and what to discard as superfluous or extra, unnecessary. Now, I've mentioned before numerous times, they're not going to hold it against you. It's not going to be something where they're going to shake their finger at you. They're going to be understanding that you don't know what you're doing because you're representing yourself. But it doesn't mean that it's okay for you to just kind of sit in that spot for the whole 5 or 6, 7, 8 years that you're going through this high conflict child custody case. You do want to continue to endeavor to try to evolve and move forward and figure these little things out and keep learning. Don't just be okay with being just kind of stuck there as a person who doesn't know what they're doing. At least try to learn. So I like to mention when I go over these videos with my viewers, when I file something that wasn't necessarily supposed to be filed, even though it didn't harm my case, I like to tell my viewers I shouldn't have done this. There was no reason for me to do this. Next document, affidavit of service. Now I could have just included this in my custom paper itself, but I guess I'm not doing that. I haven't figured that out yet. Eventually I do figure that out and I start to include it in the motion itself when I file it. That's just one less filing for the court to have to look through. And that's also what attorneys do. Attorneys will typically include the affidavit of service, certificate of service, proof of service, whatever you want to call it, in the paper that they're filing. So I'm eventually going to see that my ex's attorney does that consistently, and I will start doing that myself as well. It's just another thing that streamlines a process, less filings, less paperwork. It makes you look better because you're learning these little details. Be careful being a copycat, and what I'm saying is it's okay to copy things, but don't just copy them for the sake of copying them. Check in and make sure that what it is that you're learning or assimilating from your opponent's attorney is actually what you're supposed to do, because I do get to the point where I start to copy a lot of what my ex's attorney is doing only to later find out that it was wrong. So be careful not to assimilate their errors. Try and learn from them, but don't just assume blindly that everything that they're doing is correct, because it's not always true. Not all attorneys are always right. In fact, I don't think any attorney is always right. Some more so than others, but I'm not going to get into that with this video. So this affidavit of service indicates that I served that motion on my ex on the 28th of May. Now in this case, how did I serve her? I served her by mail, so that's good. I didn't track her down. I didn't have her personally served at work. I was conducting personal service on my ex's attorney because she was a third party. I didn't even have to see her. I would just see the front desk staff that she had, and I would drop the motion off at her office. But now that my ex is not represented by an attorney, I cannot do that. I cannot serve her attorney anymore. So rather than track my ex down, which is obviously going to add to the conflict, I just mailed it to her P.O. box, which is something that I'm allowed to do under Rule 5 of the Nevada Rules of Civil Procedure. So by mailing this to her P.O. box, I have satisfied Rule 5. I have conducted service on my ex, and it's been done in a way that has no stress attached to it, because I'm not sure how less personable you can get to taking a document, stuffing it into an envelope, and putting it in the mail. Affirmation, which is appropriate, that's required there. And we'll move on to the next document. Notice of appearance. So my ex freaks out and calls her attorney, her former attorney, and she hires her again. Now at this point, we won't be seeing her attorney withdraw at all the way up until the very end, at which point when she does withdraw, it's once and for all. So this notice of appearance is going to be in effect for several years, probably around 5 years, and my ex's attorney will stick with her for that period of time. And let's take a look here. She's got the affirmation included. Certificate of mailing is included in the paper itself, as I mentioned earlier, something that I did not do, but my ex's attorney did do. She just included the certificate of mailing as page 2 of the document. That way she doesn't have to file a separate document. Going into the aftermath, I filed 2 papers. They were free filing, so I incurred $0 in costs. My ex's attorney, because she has filed a notice of appearance, so she's back, she filed 1 document, the notice of appearance. It's a free filing, so that is $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney probably charged her 10 minutes to review the motion. It was very short. It was like 2 pages. It had 1 law, and it's not something that's brand new to these attorneys in this industry. They deal with this all the time. So I'm going to say 10 minutes for that motion, even less for the affidavit of service. I'm going to say 5 minutes for that. The notice of appearance, 0 minutes for that, because it's one of those documents that they just mass produce and put a signature on it. It just says that they're appearing in a case to represent somebody. So 0 minutes on the notice of appearance. Total of 15 minutes at the rate of $250 an hour. I'm going to say that that is $62.50, it sounds like. Hopefully the graphic is right. Anyway, if you have any questions, feel free to post something down in the comments below, and I will see you guys next time.